today is the third day of March 2021, and we are looking at meetings of companies. Meetings of companies. This is the Faculty of Law, Niger Delta University, final year students for the Law Faculty of the Niger Delta University. So good morning, everyone. Good morning, sir. I sent us the recordings yesterday. I believe that you've been able to look at them or listen to them. And I also understood that some of you already had them before. Thanks to the industry of Sandra the Quiet and a number of other students who already made it available. So we are looking at meetings. By way of introduction, I want to start by pointing out that the general meeting of the company.
Sir.
Yes, please.
I don't know whether I can just ask one or two questions.
No, we'll come to the question. Let me just make a general introduction. If you have listened to the recordings, you will know that I talked about the importance of meetings and why from time to time company law requires that the persons who come together to establish companies should be able to meet to resolve issues, purposes of disclosure, accountability, and all that. We also pointed out that companies act through meetings, that particularly the members in general meeting is a very significant arm of the company. Whether it is superior to the board of directors or not is a question for another day, but companies do act through the members in general meeting. So we pointed out from the first semester that the members in general meeting theoretically at least can be said to have the ultimate power of control because they appoint the board of directors and they also have the power to sack the board of directors irrespective of anything contained in any contract or in the articles of association. The members in general meeting can sack the directors of the company, and so from time to time meetings are required. Some of these meetings are mandatory, in which case the law requires that meetings must be called. Some other meetings can be called at the discretion of the members or of the directors, as the case may be. We said that meetings can be used for the purpose of control, for the purpose of accountability, because it is at meetings that you render account for all that you have done within the past 1 year. Particularly the directors and the other managers of the firm are able to give account to the members who appointed them on the extent of their stewardship. Again, meetings are used for the purpose of approvals and ratifications. I pointed out that Kama, in its wisdom, requires that certain actions of the company cannot be left for the board of directors. So even the articles of association cannot delegate certain powers to the board of directors. Are you with me so far?
Yes.
So we must call a meeting and table what we want to do, the course of action we want to take, and then we should seek the approval of the members. For example, if two companies want to merge, you cannot delegate that power to directors and say whatever you decide is okay, so merge. No, when you have merged, let us know. You must call the directors to approve. We also talked about ratification. Again, certain actions that are taken may require the ratification of the directors, even if it's in the interest of the members and even if they like the course of action you have taken. Kama says you need to call the members together, and a classic example is a pre-incorporation contract. Meetings again are used for purpose of clarification. So it is at meetings that the board of directors are able to explain why they did this and this, why they took this step of action and all that. Are you with me so far? Yes. Again, we use meetings for appointments. We use meetings for appointment of the external auditor of the company, appointment of directors, or you may say election of directors and all that. Meetings are also used for purpose of disclosures. Disclosures. Are you with me? At the general meetings, certain disclosures ought to be made to the member. For example, you have appointed an overage director for a public company. For a private company, a director of even 100 years can function. But once we come to the public company, because of the intense work that he's going to discharge, CAMA requires that a director who is over 70 must disclose that fact, and that disclosure should be made to the members in general meeting. That beautiful girl, focus. Can we continue? Good. Then we talk about compensation of managers under section 257 as the case may be. Also, there are issues that could arise that we may want to just note, issues that may arise as a result of meetings, notices of meetings, and who is entitled to attend these meetings, what happens if the members and the directors refuse to call meetings, what about the issue of quorum, how many members should attend, do we need to form a quorum for the meeting to commence, what about disruptions, issues of adjournments, voting, resolutions, and all that. Can we continue? Yes. Are there questions? I know you guys have listened to the audio and some of you may have questions. So if there are questions, I can take them. Yes, Mr. Sufi, let's start with you.
Sorry, sir, I may take us back.
Okay.
Because my question is not on this.
Okay.
One, that shares
Yes.
are personality
Yes.
and not realty.
Yes.
Two, that a shareholder does not have equitable and legal interest in the property of the company.
Yes.
That he owns.
Yes. No, he doesn't own the company. That's what we are saying. The
He's a member of the company.
Yes, the company owns itself. The
The company owns itself.
Yes. The highest you can have in the company is a share. It's an interest. That is corporate theory.
Yes, sir.
Of course, theory is different from practice. But what we teach here is theory, and principles. But company law, the whole idea of company law, a company having a corporate personality, just like you cannot own this man. Like you'll be talking about slavery. Is it not so? Even your children, you don't own them. So nobody owns the company. If you own the company, then the company is not a person recognizable in law. You can call it any other thing, but definitely not a person. But for company law, from the time you incorporate the company, it has become a body corporate. It has become a body corporate. Of course, it is a body corporate because of the persons who came together to form it. We cannot remove that fact. That is why initially this will be section 37, but I've not mastered the new section. But upon incorporation of a company, all the persons who come together to form that company shall become a body corporate. So it is a body corporate because of the persons that come together to form it, but they don't have any legal or equitable interest in its assets. Yes. Okay. Is it about meetings?
No, sir,
yes.
That point is still not clear. That they don't have, but I can take somebody to court on behalf of the company.
You can't just do that. You can't. If somebody is defaming the company,
yes,
or damaging the reputation of the company, or destroying the assets of the company, as a shareholder, you can't take that person to court. Are you with me? The only thing that can happen is that the members in general meeting can meet. So it is the majority. That's why I call majority rule. So what they call the rule in force and habit, we'll come to it. So yes, my dear.
Okay, sir. When in the audio, while talking about ratification,
yes,
you made mention that when a member makes secret profits, it will need to be ratified. So I want to be clear.
A member makes secret profits. Did I say that kind of thing? It can't be members. It should be directors. Yes, it's not members. Yes, please.
As regards
As regards
the last class, you said you were going to talk about something.
Yes. So I've sent you the slides for the ventures.
Yes,
Have
sir.
you seen it?
Yes, sir.
So please look it up. We need to save time.
Okay, sir.
That's why we have to just jump into meetings. Maybe any other issue, take it up with the tutorial lecturer. Or we can talk about it later. Let's cover a lot of ground. So I want us to finish meetings today. So next week we'll meet for one. On Monday, hopefully we should finish with directors. So I'll give you the audio today. That's how we'll do until. So next week we should be done with directors and secretaries and minority rule and majority protection. Are you majority rule and minority protection? So you listen to the audio, we come, we discuss. You listen to the audio, we come, we discuss. So that we can jump into administration and some of the new developments we have in Kama. Yes, quickly.
So for the purposes of that effect of the corporation, like say the
Yes.
section is
Section
42.
Yes, section 42. Thank you. Thank you. So, can we proceed quickly? Yes, so if a company wants to take a decision, corporate decisions, number one, you will insert whatever you decide in the articles. So there are certain decisions or certain courses of action that the company may want to take. They may just insert it in the articles. Number two, certain decisions may have to be taken at general meetings. If we are talking about a general meeting, then we are talking about majority of members. Are you with me?
Yes.
Yeah, majority of members can now decide. And when we again talk about majority, company law has different definitions of majority. We could have the simple majority or what you call the ordinary resolution. We could have a two-thirds majority or what you call a super majority or a special resolution. Certain other decisions that may have to be taken, for example, shortening the time for the issuance of a notice of meetings. We may have to require 95% majority. Are you with me? Yes. Then certain other decisions may even require all the members. Are you with me? Are you with me?
Yes.
All the members.
Yes, all the members may have to assent. For example, you want to a limited company want to change it to unlimited, limited to unlimited. You have to require the assent of all the members. So here you are not talking about 95%, you are talking about 100% majority. And that majority must even be in writing, so written assent. Not just that they agreed, not just that the chairman said, let's count. 100%. Can we continue?
So is that possible?
Yes.
To get 100% attendance in a meeting?
Of course. Even if for purpose of reduction of the for purpose of altering or reversing a company from limited to unlimited, what Kama actually requires is written assent, 100%. So in that case, and just like he's pointing out, Kama envisages a case whereby even if all do not attend, all must consent. Are you with me? Are you with me? Yes. So all who attended must assent. Even those who did not attend, we still need to get their written consent. Let's continue. Okay, so types of meetings. Types of meetings. So there are different types of meetings. Again, you will come across them as you are reading the provisions of Kama. So there's a statutory meeting, or what they call statutory meetings. These are usually for public companies, newly incorporated public companies. And I pointed out in my audio lecture, I want to believe that it's unclear if a private company that is converted to a public company is required to hold a statutory meeting. And it is my view that it ought not to be, but we are not clear. But the tenor of Kama appears to indicate that the statutory meeting is to be held by a newly incorporated public company. Are you with me so far? Yes. So that is the public company, and it must be held in Nigeria, and it's only for public company statutory meeting. And the aim, we'll talk about the aim, then we'll talk about the AGM, or annual general meetings. This is the most common, mandatory again, we'll talk about it. The EGM, extraordinary general meeting, class meetings. Class meetings, I talked about classes of shareholders. So there could be different classes of shareholders, there could be different classes of debenture holders as well. And these different classes of shareholders or debenture holders may also be required to hold meetings. Just a second. Okay, trying to also get the... So, 3rd of March 2021, trying to get the audio recording as well. Can we continue?
Yes.
Yes, we could have meetings of directors. This is not necessarily mandatory, but it does happen, and KAMA also outlines the procedure for meetings of directors, meetings of the bench holders, and meetings of contributories. I think I talked about contributories in the audio. Yes, good. Okay, so some matters that can be handled only by meetings, I'll just run through. I won't run through all of them, just a number of them. Okay, so alteration of the memorandum and article addressing issues on serious loss of capital and conditions on the issuance of shares, variation of class rights, appointment of directors, and all that. Appointment of directors, just to point out, mustn't be held by the general meeting. By default, it ought to, but directors may be appointed by persons other than members of the company. Directors may be appointed by persons other than members of the company. A creditor, for example, may be given the power to appoint directors. So when you get the slides, please just note that. Let's move on. So these are some matters that are usually addressed by meetings. For right to attend meetings, please see sections 107, 251, and 252. Right to attend meetings. Remember that every member of the company ordinarily ought to have the right to attend, not just to attend, but also to speak, and not just to speak, but also to vote. So attend, speak, and vote. Attend, speak, and vote. And if you cannot attend, then you have the right to appoint a proxy to represent your interest. But note that under section 107, the articles of association may provide that a shareholder who has not paid for his shares upon calls validly made upon him may be disentitled from attending meetings. Are you with me? A shareholder who has not paid for shares despite calls having been validly made upon him to pay may be disentitled from attending, from speaking, and from voting. So let's just run through the statutory meeting. Again, it is held just once. It is not a meeting that is held frequently. Victoria, are you with us? It's like you are somewhere. Sit properly, sit straight. Good. Okay, so it is held once in the lifetime of a public company. It must be held within 6 months after the company is incorporated. But again, CAC, no, I think the courts should be able to extend time if the company is not able to do that within 6 months. So it considers mainly pre-incorporation matters as detailed in the statutory report. So before the meeting is held, a report called the statutory report ought to have been sent to all the members for them to consider. Headman, hit that man, tell him to stand up. Tell him to stand up, he has been sleeping since. Can we continue? I won't call anybody's name. If what I will say will embarrass the person, so that prosperity will not laugh at you. Stand up small. Can we proceed? So the statutory report ought to have been certified as correct by an auditor before it is presented, and it must be held, the meeting must be held in Nigeria. Failure to hold the meeting is one of the grounds upon which a company can be wound up by the courts. So is that important and is that serious? Again, in my audio, I pointed out that in the past, a newly incorporated public company couldn't just jump into business. It required a certificate of trading before it could commence. But now, KAMA has removed that provision in Nigeria. The UK, it is still the requirement. For Nigeria, you can jump into business, but in place of the requirement for a trading certificate, we now have the requirement for the statutory meeting. Are you with me? Are you with me? So it is at that meeting that you can address what you call pre-incorporation matters. It is at that meeting that you call upon the members to ratify a pre-incorporation or pre-incorporation contract and table before them the course of direction that you want to take the company to. Again, failure to submit the statutory report is also a ground for winding up. So if you don't hold the meeting or if you don't submit this report, then it's a ground for winding up of the company. So let's run through the AGM. We'll talk about it in the audio. The AGM is the most important, if you may, and most frequent, because it is the only meeting that is compulsorily required to be held annually. Are you with me so far?
Yes.
And we pointed out that it must be held once in a year. It must be held within a 15-month period. So even if you hold the AGM in 1977 and you hold it in 1978, you may still be in violation of the law if these meetings are not held within a 15-month period. Any questions so far on this issue?
Yes, sir.
Yes, please.
Sir, you said the meeting must be held in Nigeria, the AGM must be held in Nigeria.
Yes. Not all, not for if you notice, it's not compulsory for SMCs, single member companies, nor is it compulsory for small companies.
Considering this new innovation of Kama, online meeting, is it that the meeting must be in a physical environment, then people can join online, or everybody can start a meeting from online?
Let's look at section 240. 240 subsection 2.
Okay.
If somebody there can read it.
Okay. The private section 240 subsection 2.
Yes, please.
A private company will hold its general meetings
Yes.
electronically, provided that such meetings are conducted in accordance with the articles of the company.
Excellent. So it's only private companies that can hold their meetings, AGM and all that, electronically. For public companies, you still need to meet physically. It makes sense. Yes, please.
But they didn't know, they were not expecting COVID.
In view of a natural disaster.
How?
We meet physically in view of a natural disaster.
Then you extend now. That's why CAC can extend the time.
Okay.
Yes, you can change the environment. It can be held anywhere in Nigeria. Yes, my dear.
So please, I actually don't understand the calculation because in the audio I was trying to explain how
Yes.
to calculate within 15 months.
Don't worry, I'll explain it again. That is why I'm here. Are you hearing? I'm here for you. Yes, my son.
So I want to be clear on this one. The statutory meetings is just for public companies.
Yes, please. Only a public company is mandated. So we talk about the calculation again. Number one is that the meeting must be held within 15 months. For a newly incorporated company, it can be held within an 18-month period. Are you with me?
Yes.
And if you are holding it within an 18-month period for a newly incorporated company, you need not hold it in this year or in the next year. So it can be held in the third year. So 18 months, therefore, encompasses one full year. Is it not so? Yes. Plus 6 months. So if you hold if the company is newly incorporated in August 2018, it needs not hold its annual general meeting in 2018. Because from August to December, you have 5 months. It need not hold its AGM in 2019. Because from January to December, you have 12 months. That is 17 months. Are you with me? Yes. But it must hold it in January 2020. So that is for the newly incorporated company. You can hold it within 18 months. And in doing so, you need not hold it in the year of incorporation or in the other year. You can hold it in the third year. That is the first thing. For every other company that has been incorporated, the law says hold it within 15 months. And in holding it within 15 months, you must do so within a 2-year frame. I mean, we are between 2 years. So you cannot hold your AGM in October 2018. Then when you hold it in October 2018, 2019 you refuse to hold it and hold it in 2020 because you are still within a 15-month bracket. Are you with me? So October 2018 to about March 2020 is a 15-month period. But in doing so, you'll be in violation of KAMA that says the meeting should be held every year. KAMA did not say the meeting should be held within just 15 months. If KAMA had said, hold your AGM within every 15 months, then you would have been allowed to hold one AGM October 2019 and the next AGM March 2021. Are you with me?
Yes.
Rather, you must capture each year. But again, in doing it in each of these years, like I said in the recording, you mustn't say we held the first AGM January and we hold the next AGM December of next year. After all, we are doing it every year. You are doing it every year, but you are now looking at a 23-month period. Is it clear, my child? Is it clear, my child? Good. Yes, somebody was raising his or her hand there. Quickly. Okay, no. Okay, so again, CAC may extend the time for you to hold the AGM, but it cannot do so beyond 3 months. But CAC cannot extend the time for you to hold the first initial AGM. The initial AGM must be held within 18 months. And if you don't do that within 18 months, CAC cannot extend time. But for every other AGM, you must hold it within 15 months. If you are not able to make up that 15 months, CAC can extend time, but no more than 3 months extension. Examples of what kind of businesses are conducted at the AGM. Talk about special business, ordinary business. Sandra, give me 2 examples of ordinary businesses. Ordinary business. Somebody help Sandra. Yes, my child. What is your name? Aiba Derry. Oh, that's my friend's daughter. Oh. My friend's daughter. How are you? How are you? No, the time has passed. Let me hear from this my daughter. Okay, what else? Yes, what else? Can somebody help now? Another person? Yes, there.
Presentation of financial statements.
Good. The girls are doing very well today. Only Mr. Sufi is covering for the males, so for the men. Somebody should rise up. Okay, let's move on. So every other business is a special business. For the ordinary business, you don't need to itemize. Once you say in the notice of meetings, what we are going to consider is ordinary business, it is already deemed that, you understand what has just been mentioned, appointment of directors, appointment of auditors, replacing auditors that are retiring, declaration of dividends and all that is what we are going to discuss. There are about 5 or 6 of them. Please note them. Every other thing is a special business. It must be itemized, it must be detailed, otherwise it shouldn't be raised up. It ought not to be raised up at the meeting. Are we good so far? Okay. Again, it's an offense not to hold the call for the AGM and all that. So let's move on. So please see default in calling the AGM. Default in calling the AGM. The AGM is dealt with by section 235 of CAMA. So you may want to look at it. And see 240 again for place of holding the AGM. For public companies, remember Nigeria. Private companies, if it's a private company, so if I ask you in the exam, a private company need not hold an AGM, will you agree? Any of them? A private company need not hold an annual general meeting, will you agree? Would you agree? Cynthia?
If it's a one-man company, like you have rightly said, need not hold annual general meeting.
So a private company need not hold an AGM. Do you agree? Headman, do you agree? Yes, my dear. You are raising your hand. Yes.
I know the newcomer states that section 241 states that it is now optional for private companies to hold annual general meetings, that they can do it electronically.
No. Yes.
A single man company, a closely held company.
No, I didn't call closely held. Stick to the law. A private company need not hold an AGM. Do you agree?
Yes, I agree.
Wrong. Wrong. A private company that is not a small company must hold. Only a private company that is a small company or an SMC. So, and we could have a single member company that is not a small company. Not all small companies are single member companies. And not all single member companies are small companies. A single member company is a private company, whose turnover does not exceed a particular threshold. You remember? You remember? Yes. Excellent. So once a company is a small company, of course it's already private, it mustn't hold an AGM. 2, a single member company, even if it is not a small company, because its turnover is in billions, still mustn't hold. Are you with me so far? Still mustn't hold an AGM. It may if it wants to, but it must. A single member company doesn't. Who are you meeting with? One person cannot meet with himself. So all single member companies don't need to hold AGMs. All small companies don't need to hold AGMs. Senator's wife, you are coming in now. Senator's wife. Can we continue? Senator Favor, Senator Mrs. Favor. Don't come late to my class again. Every other private company, Shell is a private company, SPDC Limited, but its turnover is in billions. It must hold an AGM. So please draw that distinction. I may try to catch you off balance in the exam. So try and draw that. Again, like you said, for private companies, they can hold their meetings electronically, which is a major plus. They must, but in doing so, they must comply with the articles. Okay, let's look at the EGM. My daughter Apam, who can requisition an EGM? Annabelle, distinguish between convening and requisitioning EGMs. Convening and requisitioning. You have listened to my audio now. What are you looking at? I was praising you people to my petroleum law students. That when we come, we just discuss because you have listened to the audio. Them, they are still joking. Help us. You've not listened to the audio. Annabelle the Young. Yes, let somebody help us. What is the EGM about? Oga, the man behind Sinte. What is his name? I will remember it, I will forget. That Oga, yes.
EGM.
What is his name again? Pigancy. Help us. What is the EGM about? Extraordinary General Meeting.
These are meetings that are called in case of emergencies. They are not part of the annual general meeting.
Okay, thank you very much. So the EGM is just like the word used, Extraordinary General Meeting. It's called to address an issue that cannot wait till the next AGM. It's a general meeting just like every other AGM. But in this case, certain things have arisen and we cannot wait for them. It's too urgent. So an EGM can be called. Three sets of people may call for this meeting. 3 sets of people may call for this meeting. Number 1, the board of directors at any point in time, they can convene that meeting. Number 2, if all the board of directors, if all the directors have traveled, then a single director, if something arises, can convene the EGM. Number 3, the meeting can be requisitioned, in which case members are the ones now saying, call an EGM because something is happening and we cannot wait. Are you with me so far? I take it again. Number 1, the directors acting as a board can inform the secretary, call for an EGM. Number 2, if all the directors are out of Nigeria and we have only one director on ground and something is happening, they can also, that one person can convene an EGM. Number 3, the members of the company representing a particular percentage of the paid off share capital of the company, that should be about 10%, 10%, yeah, they can also requisition. In this case, they are not calling, but they are asking the director, this is our number, this is what is on ground. In view of what is on ground, please call an EGM. Are you with me? Yes, sir. If he fails to do so, then they can proceed to convene. So they have told him to call. He's dragging his feet because probably what they want to discuss may not be in his favor, and so they can now proceed to call. And when they call for that meeting, all the expenses all the funds that they expend in calling for that meeting, he will have to bear the cost for them. Please see section 239. Are there questions? Yes, please. Yes, may also be called, that is why it's good to write. No matter how intelligent you are, you forget some things. It may also be called by an auditor. It can also be requisitioned by an auditor, section 413. Section 413. Again, I talked about the auditor and instances that could lead him to call the EGM. Didn't I say that? Yes. Good. So, go back again and listen to the audio. You want to ask a question?
Is there any possibility that maybe there will be no director at all
Yes.
in Nigeria?
Yes.
In that case, what would you do?
Good question. If there's no director at all in Nigeria,
Members.
interestingly, Kama does not provide for. Yeah, that is a lacuna. Thank you for pointing that out. I will look into it. But Kama doesn't provide for a case where there's no director. And but again, if there's no director, the whole idea is that if the members should be able to requisition, and if the directors fail, call a meeting, then I want to believe that equity can also come in here to empower them to call an EGM. Are you with me? Good. So just look at these sections again and note them.
Add an adult director in that instance.
No, there's no provision like that. Okay.
Excuse me, sir.
I'm coming in just a minute. Just note that under section 137, section 137 is the only instance where an EGM must be called. Must be called. Must be called. And this is when there's serious loss of capital. Serious loss of capital. Look at section 137. When the net assets of a public company, under the old Kama, it was public or private. But now it's been limited to just public. Where the net assets of a public company are half or less of its called up share capital, the directors shall, not later than 30 days from the earliest day on which that fact is known to a director of the company, duly convene an EGM of the company for a day not later than 60 days from that day, for the purpose of considering whether any and if so what steps should be taken to deal with the situation. So look it up. There's serious loss of capital, then Kama says you must call. And if you fail to call, again it's an offense. Yes, Mr. Sufi.
Yes, sir. So we'll be talking of meetings, general meetings, annual general meetings.
Yes.
Extraordinary general meetings.
Yes.
And I know that companies must have a secretary.
Yes.
Is it the same secretary that will take the notes in AGM, EGM, and all the meetings?
Excellent question. Excellent question. Yes. The secretary can also work with a team. We'll talk about secretaries after we talk about directors. The secretary of a company could be a firm, a law firm. Okay. You understand? And so who is your secretary? Your secretary is not Barrister Asufi. Your secretary is Asufi and Partners. Okay. In which case, any lawyer in that firm can exercise secretarial duties. Okay. Secondly, a secretary can function through an assistant or a deputy secretary. So you deputize, you send people, and all that. Let's move on. Okay, notice of meetings, length of notice of meetings. Please see section 241. 241. Usually 21 days. Usually 21 days. Usually 21 days. But I said that 21-day period can be shortened for the private company if about 95% of the members agree. Let's just look at section 241 quickly. Can somebody read for us? Okay, I nearly called you yesterday, Seth. I wanted to give you money so that you'll be buying water for me because you have been doing so well.
Okay. Section 241.
Please meet me after the class. Yes, please.
Section 241.
Yes.
Length of notice for calling for meetings. 1. The notice required for all types of general meetings is 21 days from the date on which the notice was sent out.
Look at 2.
2. A general meeting of a company, notwithstanding that is called by a shorter notice than that specified in subsection 1, is deemed to have been duly called if it is so agreed in the case of A meeting called as a general meeting by all members entitled to attend and vote, and B, any other general meeting by a majority in number of the meeting, by a majority in number of the members having a right to attend and vote at the meeting, being a majority together, holding at least 95% the nominal value of the shares.
It's okay. It's okay. Thank you for that. So, first of all, 21 days. Secondly, the members of the company may agree to shorter notice. Are you with me? Are you with me? In agreeing to shorter notice, for the AGM, all the members must agree. And say, rather than give us 21 days, give us 3 days. For any other general meeting, which of course we are talking about the EGM, then we need 95% of the members to agree. So we're talking about super majority or complete majority. Please note those facts. Okay. Mode of notice. Please note the mode of notice. Usually, how do you deliver the notice? It should be by post, or it could be given to you personally. Are you with me? And now, emails can now be used. So that is one of the innovations of Kama. We can also use your email address, provided you give us your address, which I think is a major plus. Persons entitled to be notified. Please note, persons entitled to be notified. Usually the members, the directors, the secretary, the auditor. But Kama 2020 has now added a CAC for public companies should also be notified. For public companies, CAC should also be notified. Okay. So 6242 for contents of the notice. The whole idea is that they give us adequate information to enable us to decide whether or not to attend the meeting. Give us sufficient information whether to enable us to decide whether or not to attend the meeting. So for persons entitled to notice, see section 243, see section 243. Okay, for public company again, you may need to give an additional notice in two national dailies. That is 246. And the effect for failure to give notice, if you fail to give, again, it quashes the whole meeting. And I discussed that at length, that why should we have to quash the whole meeting because one person was not notified? That shouldn't we say that if that person, number one, is uncomfortable with a particular resolution, then we can quash that particular resolution rather than to quash the whole meeting. Are you with me so far? Yes. Yeah, so that is something you may need to also look into in future for those of you that want to do research. Okay, so court ordered meetings 247. Yes, please.
Mode of notification.
Yes.
I own shares in UBA and Zenith Bank, and they also send us text messages.
Okay.
For meetings. So I think.
No, the law does not say text. It says email.
Email.
Yes. Electronic mail. The text will not be elaborate enough, probably. And they did not capture social media platforms like WhatsApp and all, but all those are also very efficient means of communicating. But again, the email is perhaps more valid. It's easier to lose WhatsApp messages than emails. Emails you have sent, as I've sent as far back as 2002, 2003. I can still trace them. But WhatsApp, you change your phone, you may not, except you do proper backing and all that. So for now, it's just email.
Okay, no wonder they still say they quote the newspaper.
Yes.
Yeah, they also quote the newspaper that you should check on so date.
Okay.
So date. Okay.
So let's talk briefly about voting. Again, I talked about voting, that companies resolve by votes, because the underlying concept of corporate governance is democracy. It's democracy. Madam, Martha, sit up. No looking at your phones. Focus. So companies, the underlying principle of corporate democracy or corporate governance is corporate democracy. I know when we're talking about democracy, we're talking about what? Majority. Is it not so? Yes, so members meet together and then they vote. They carry decisions by vote. The default rule, originally, was that we decided by majority of persons, majority of members. But over time, it was felt that that was a disincentive to persons who wanted to invest in the company, because I will not be incentivized to invest in a company if my decision-making power does not correlate to my commitments financially. And so we now had the option of voting in proportion to my commitment, which is what we now call voting by shares or voting by poll. Are you with me?
Yes.
So voting by poll, we are saying 1 share, 1 vote. So the man who has 100 shares has 100 votes. Voting by show of hands or voting by person, we are saying 1 person, 1 vote. You know, so. But again, not everybody must vote. So we talk about abstentions. So if we decide to carry out an issue, we may have voting, we may not have voting. Who may demand a poll? Please see section 249, see 249. Under what instances may the articles of association exclude the right to demand a poll? Under what instances may the articles of association exclude the right to demand a poll? Again, see that in section 249. Minor, unimportant instances, adjournment, election of the chairman, and all that. Apart from that, the right to demand a poll is an inalienable right. The articles or contracts cannot remove from the members that right to demand a poll. Who may demand a poll? Please note 3 categories of persons that may demand a poll. The chairman, if he's a shareholder, 3 members present in person or by proxy, or any member. That in this case, we're talking about one particular member who holds shares up to 1/10 of the company's total paid-up capital. Are you with me so far? Are you with me so far? Yes. Are there questions?
You said chairman?
Yes, sir. The chairman, if he's a shareholder,
Okay.
he can demand a poll. And I said, then number 2, 3 members. Mr. Idisi. Odusi, yes. So I said 3 members present in person or by proxy can also demand a poll. 2 cannot. Except they are now demanding a poll on the basis of their shares. Then they can say we are demanding a poll because we have 1/10 of this company's paid-up capital. In which case, even 1 person can demand a poll. I may ask you in the exam, 1 person can demand a poll, and at the same time, 1 person cannot demand a poll. Explain. 1 person can demand a poll if he's doing that on the basis of his shares. 1 person cannot demand a poll if he's doing that on the basis of his number as a person. In which case, he will need 2 more persons to join him. And I also want you to note that even after the company has decided an issue on show of hands, the matter is not conclusive. A poll can still be demanded on that same issue. Annabelle, are you with me? So the matter has been decided, but I'm not comfortable. I don't like, so let's go back and decide it on a poll. Any question, please? Any question? I pointed out, I tried to explain, if you listen to my audio, I tried to explain why the poll is very, very important and crucial. And I said that in some countries it's been advocated that directors and shareholders should merge, and so we should not have 2 different strands of corporate governance. But I said that if that were to be the case, it may be disadvantageous to a substantial shareholder because directors vote in person. So if we have 5 directors, even if I have 95% of the company's share capital, I still have only 1 vote. Directors do not vote according to their investments, because as directors, they are not investors. They are agents of the company, employees of the company, and they are pursuing only one thing, the interests of the company. They are fiduciaries. But in your capacity as a shareholder, the primary thing, your primary motivation is interest, your own profit. Are you with me? Yeah.
Can a director,
yes, please,
waive his right to vote as a director and then decide to vote as a shareholder?
Yes, he can. He can. But remember that the meetings of directors are to address things that are totally different from what the members are addressing. Directors meet to address and deal with the day-to-day affairs of the running of the company.
Okay.
Yes. Or at least to devise the strategic policy of the company. But members could meet just once a year. Directors may meet 4 or 5 times a year, and then they try to give the company strategic focus. Okay. Quorum. Pereowei, explain to us the law of quorum. Yes?
Quorum is just a particular number of people that should be present in the meeting.
Okay. The minimum number.
Minimum, yes.
Yes, so what is the quorum for companies in Nigeria? There are 3 different headings. Listen to the audio now. No, Mr. Subai, I know you like him, but this time keep your likeness. Let him answer. Derry. Yes.
I can't remember, but I think it's one third. No, if the minimum number is not.
Which one third?
Yes, yeah, help us.
Is either 1/3 or 25, 1/3 member or 25.
And what else? There's another one you're missing. Yes? Prosper, help us. Don't answer for them, okay? I know you like them. Prosper, help us.
I think it's simple majority and
Why are you doing like this now? We're talking of quorum. Talking of quorum, not majority issue. What number of persons do we need before we can start the meeting? We have called the meeting. Some people are already here. Some people have not come. Should we start? Should we not start? No, we've not yet formed a quorum. What number do we need? You could be a secretary tomorrow, and these are the things they will ask you. Yes, my dear.
Okay, like they say, okay, to form a quorum, so it should be 1/3 or 25
Members.
Out of the total members. Then, if the total number of members cannot be divided by 3, it should be, the number nearest to 1/3. Then, if the total number of members is 6 or less than 6, it should be 2 members.
Thank you for trying. Okay, so quorum, like she said, 6 members or less, 2 members. Of course, this applies by default. Members can alter it in the articles. So by default, 6 or less, 2. Once it's more than 2, quorum is 2/3 of the members. Are you with me? Are you with me? Yes. Once the number is more than 2, quorum is what? 2/3. More than 6, sorry. Quorum is 2/3. But like we all know, so if there are 9 members, quorum is 3. And no, 1/3, not 2/3, 1/3. Quorum is 3. There are 12 is 4. In there are 16. In there are 12 is what? Is it 4? Yeah, 4. Good. But like we all know, we could have numbers that are not divisible in 3s. You cannot divide a human being into, you understand what I'm saying? So if you have 10 members, for instance, then how do we ascertain 1/3? So Kama now provides that the quorum in such instances, once it's more than 6, then the quorum will be 1/3, or if we cannot get exactly 1/3, the nearest number to it, if it's not a multiple of 3, the nearest number to it. Are you with me? And not just the nearest number to it, but whichever is less. Whichever is less. Let's look at 256. Quickly, because of time. Thank you, Lord. I'm coming. Subsection 2. Can somebody read for us?
Section
Yeah, good. Read subsection 2
of
256. Let me read because of time. Except in the case of a company with one member, or provided in the articles, the quorum for the meeting of a company is 1/3 of the total number of members of the 1/3 of the total number of members of the company, or 25 members, whichever is less. Yeah, so it's 1/3 or 25, whichever is less, present in person or by proxy. But where the number of members is not a multiple of 3, then the number nearest to 1/3. But where the number of members is 6 or less, the quorum is 2. So I hope we are clear. Are we clear? Yes. Good. So let's move on. So please look it up again. Discuss it among yourselves. Okay, so resolutions, please look up resolutions 258, 258, 258, 258. We'll talk about written resolutions, talk about ordinary resolutions, and we'll talk about special resolutions. Then resolutions requiring special notice. What is special notice? Resolutions requiring special notice. Simply 28 days notice to the company. Then the company will give 21 days notice to the members. Resolutions requiring special notice. 28 days notice to the company, and then 21 days notice to the members. So certain resolutions cannot be passed at meetings unless special notice has been given to the members to enable them to adequately prepare. So please look at sections 282, 282, 288, 411. So if you want to remove a director of a company, if you want to propose that an overaged director be elected, that is section 288, or if you want to appoint auditors, section 411, I think, so you have to give to the company special notice, and then the company will notify the members, giving them 21 days notice. So please note those, just 3 instances in the law. Any questions so far? Any questions so far? Okay.
Let me ask.
Is it related to meetings?
Yes.
Good.
If quorum of 1/3 is used to determine the number of persons that should be in a meeting,
yes,
that should attend the meeting, if the persons who are supposed to be members are 9,
yes,
it means we have 3 persons at the quorum.
yes, yes.
Now, what of in a situation where such a meeting is called, and one of the persons who was absent in the meeting has majority shares in the company, maybe
yes,
70% or thereabout, and a decision is reached in that meeting,
yes,
will
it affect him?
Definitely. Will the decision be valid?
Yes, it will. Thank you for raising that up. So meetings, thank you for pointing out. When we talk about quorum here, we are not looking at shares. We are looking at persons. So even if you have 99% of the company's shares, a quorum must still be formed. And to form that quorum, we need to count human heads separately. You understand? We need to count human heads separately. So if a company has 1,000 members, Mr. Sufi, what will be the quorum?
300.
No.
1,000?
Yes.
3,000?
No. 25. That is what I read, and I asked you, did you understand? You're all in unison. You said yes. And I did not understand. I knew, but I just... Yes, no, 25. I'm coming. We're reading it together, section 256. We did not read Ijaw or Igbo. We read English. If it is 1/3 or 25, are you with me? So if the company has a large number, let's say 20,000 members, then we cannot start talking about 1/3. Once we have 25 people, we start the meeting. Hey. Injustice. If the company has 60 members, 1/3 is 20. Is it not so?
Yes.
Yeah, whichever is less, so 25 or 1/3, whichever is what? Yes. Less. So in this case, the quorum will be 20 because 20 is less than 1/3. If the company has 59 members, what is the nearest number to 1/3? Sir? The nearest number to 1/3 will be the quorum. Can somebody do calculation? Get your phone. We have 59 members in a meeting. How do we ascertain the quorum? Yes, sir.
It's 19.6.
Okay, so 19.6 is the number nearest to 19.7. Yes.
19.7. Half point. You cannot have half human.
19.7.
You cannot have half human.
It's 19.
That's why you have to approximate now.
Approximate
No,
to 20.
it's 20. 20 is nearer. 19.6 now. 19.7 is nearer to the whole number.
Yeah.
Yes. If it was 19.4, they would have said 19. Sir? Yeah, it's 20 now. So the quorum is 20. So I hope it's clear. Should we take it again?
Yes.
Yes. So 4 things we need to point out. 4 things we need to point out. Number 1, if the company has 6 members or less, quorum is 2. Number 2, if the company has members above 6, basically the quorum is 1/3 or 25, whichever is less. 1/3 or 25, whichever is less. It is 25 if, for example, the company has 500. The company has 600 members. 1/3 of 600 will be how many, sir?
200.
200. So 225, which is less?
25.
25 is less. Whichever is less. 1/3 of 25, whichever is less. If the company has 60,000. The company has 60,000 members. 1/3 is 20,000. 20,000 and 25. 25 is less. So we take the lesser number. If the company has 30 members, 30 members, 1/3 of 30 is what? 10. 10 is less than 25. So we take which one?
10.
We take 10. But if the number is not a number that can be divided by 3, we cannot have 1/3. Example is 19. Then we take the number that is nearest to the whole. So 19, sir, do for us quickly. Odusi, do for us. 19 should be 6 point something now. Or is it 7?
Yeah, 6 point.
It's 6 points.
6 point what?
It's 6.9, so it's going to be 6.
So it's going to be 6. So please get the audio, listen to it. If you cannot understand it, spend some time praying, and then there's a God in heaven that reveals secrets. Okay, let's talk briefly about progs. Okay, power of the chairman. Power of the chairman. Basically, he has a casting vote. If it's a chairman, he can demand a poll, and he conducts the meeting. These are his 3 basic powers. These are his 3 basic powers. The power of the chairman. Sir? He has a casting vote. In the event that there's a tie, in the event, casting vote.
But if there is no tie, it doesn't.
Then no, he doesn't. So he himself can vote. But if there's a tie, then he has a second vote.
Okay, you can vote if he's a shareholder.
Yes, he can vote. So
As a shareholder.
yeah, we are voting. Casting vote, you bring it when we're talking about basically voting by show of hands, basically. So there are 4 of us. I'm the chairman plus Kolo, Bekowe and Tarilaifa Ben. They are on one side on a particular issue. So we've all voted. We now have 2-2. So it's a tie. It's a deadlock. So as the chairman, I have a second vote. Are you with me so far? Excellent. So number 2, he can demand a poll. He has that exclusive power to demand a poll, irrespective of his shareholding in the company. Even if he has just 1 share in the company, he can still demand that this matter be resolved, not by show of hands, but by a poll. Thirdly, he has the power to conduct the meeting. He has the power to conduct the meeting. Thank you, Lord. I'm trying to get the section. Okay, please check it up later. It should be about section 2.5 something. So he conducts the meeting, and here the position of the chairman is very crucial and very important in directing the company. There's an article I'm going to give you after now. Sandra the Quiet come to my office. I'll give you that article so that you photocopy for the rest of the class. Is it okay?
Yes. Sir?
Yes.
Quick one. Who may be a chairman in a meeting?
Okay, so very good question. The chairman of the meeting basically is the chairman of the board of directors. The chairman of the board of directors, he chairs the meetings of the company. But if we all gather for meeting, is not there, then after 1 hour of the meeting, the directors, the members can appoint somebody to chair the meeting. Are you with me? Are you with me? Good. And one innovation of Kama now is that the chairman of the company must be separate from the managing director. You can't merge both again. Yes, my dear.
I wanted to ask if the chairman is managing director.
No, it's not the same. For public companies, it's not. For private companies, you can still merge both offices into one person.
Managing director.
Yeah. Or CEO. CEO is the same thing as managing director. Proxies. So please look up section 254. 254. A proxy is somebody who represents. That is what it does. I can't go for the meeting, so I can send somebody to represent me. 254.
Like anybody can be a proxy.
Anybody can be a proxy.
And the proxy can equally vote.
Yes, he can vote. I'm not very sure if he can speak. He ought to be able to speak, but I think Kama is a bit silent on that. Yes. So please, circulation of members' resolutions. Just look from 250 to 266. Circulation of resolutions. For example, we are about to meet, and usually what happens is that the directors will determine the agenda, and they will determine the matters to be resolved at the meeting. But we could have an aggrieved member of the company. If you notice, when you read our meetings, the focus is on members, not shareholders, because shareholder is not synonymous with member. Are you with me? Are you with me? Yes. Shareholder is synonymous with member for a share capital company. But Kama is also capturing guarantee companies. And so most times the focus is on member, not shareholder. Let's note that. Again, you can be a shareholder and not be a member, because your name has not been entered into the register of members. So to be on the comfortable side, we use the word member. Is it okay? So directors determine the resolutions to be addressed or to be voted on at that meeting. But as a member of the company, I may feel we should vote on this matter. And so Kama section 260 gives to me that leverage to require the company to in advance circulate my proposed resolution, which should also be among what should be determined at that meeting. So please look at section 260. Under what instance would my request not be sanctioned? If I have a vexatious or libelous claim, please let us vote on this matter that Director this impregnated his daughter. You know, we have people who are very troublesome. Yes. Where I'm staying now, we're having an issue. We wanted to move to what they call 33 kVA line. All the landlords were required to pay 400,000 naira. We all managed to pay. And then PHED promised us that they will be giving us 20 hours of light. And they will cut us off from the community around us. Because those people that they are not using meter, they are bypassing. So for them, PHED is using, is it prepaid, they call it? We will have meter, so we paid the money. And then we began to get the light improved. It was not up to 20 hours, but sometimes you could get 18 hours, 17 hours, once in a while 24 hours. But all of a sudden, one member of the estate just arose and said, fraud. That it was fraud, because the money amounted to millions, about 30 million. By the time we gathered everything, and so he has now alleged fraud. So we're trying to call an EGM to address that. Why am I saying that? We could have a meeting is about to be held. Are you with me? And an aggrieved member feels that this matter should also be discussed. So this particular man It's just that in his own case, he's a troublesome person. He doesn't pay estate dues. It's, everybody is going like this. You are going like this. That is that kind of person. They say if you have a plot of land in the estate, clear your plot because it can breed mosquito and snakes for your neighbor. In his own case, he refused. His plantains have now grown to be entering the other man's compound. The man went to cut it off. He went and damaged all the man's lights. He's an architect, though. So it's not education that makes a man civil. No. You can have your PhD and be very crude and uncivil. Have you not seen lawyers fighting? Physically, on the road, in the courts, whole time. Because they're not civilized. Okay, so Karma now provides that if the matter being alleged is vexatious, frivolous, it contains defamatory matter, then we will not have the obligation to circulate such a resolution. And we can even sue him for wasting our time and energy. The company can sue him. So you just wake up and say, that man has impregnated his daughter, or is a homosexual. How do you know? Are you with me? So please look at section 260, 262, registration of resolutions and all that. So we're almost done. Look at section 265, powers and duties of the chairman, and minutes of meetings 260. So basically, this we have covered meetings of companies. So I want to thank you for your time. My young friend can now end the video. Thank you for your time, and